Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia. We had so much fun here yesterday. Let's start again today. Magistrate Chisholm.
Mr. Kennedy, can you unmute yourself and turn on your camera, please? Mr. Kennedy, please turn on your camera. Mr. Kennedy, can you hear me? Mr. Kennedy, can you hear me? I'm not muted. Back to the way. And Mr. Pardos. This is Officer Fedison's. Mr. Fardos, please unmute yourself.
Good morning.
Morning. Your citation is 26 BE 02720. You were cited for operating on expired license plates back on the 28th of May. When did you get the new plates or tabs?
June 4. I
Did you
re-registered
have the
it.
registration with you today?
I have the receipt for the registration. They didn't send it to me yet. They didn't send me any registration in the mail. I'm still waiting for it.
But you have the receipt?
I have a receipt for it. I paid for it.
Okay, can you unmute your, or not, can you unblur your background and then you can put the receipt in front of the camera?
I could share it on my screen. Is that okay? I don't have it printed.
Right.
1 second. Here is the receipt.
Can you make it bigger?
Sure.
And the date on that is June 4th.
Correct.
It's the same license number.
Yes.
Is there anything you want to add to this, officer?
Wish I could verify. There we go. That's on the Hyundai Tucson.
Correct.
Well,
Yes.
it doesn't show on the receipt what the vehicle is. They just have the plate.
Right. I can see here, Your Honor, that he has updated his registration. I'd like to get rid of that citation, sir.
Is this a motion to
Motion.
dismiss?
Thank you, Your Honor.
Okay. Okay, Mr. Fardos, you are good to go. Thanks to the officer's motion, the ticket is dismissed.
Awesome. Thank you, man. Have a good morning.
You too. And did you see a Pearson on the docket? Pearson. I don't.
Do not.
iPhone Church. I don't see a Church in the docket either.
Good morning. Here's Pearson.
Here's Pearson.
And who is the walk-in?
Could be Mr. Gonzalez. I think Ms. Cole is for schedule, but
Nobody. Really about.
Everybody. Yeah, so everybody.
Mr. Pearson, as soon as the attorney gets in, you'll have a chance to speak privately with an attorney before you're arraigned on these files.
Okay, I appreciate it.
Scheduled is Cole.
And this is Watkins and Juan Gonzalez. Mr. Gonzalez, can you hear me?
I can hear you.
Okay, we have a walk-in. He's got two files, both from 2023. Gentleman's name is Dante Maurice Pearson. One file is a Berkeley file, the other file is a Royal Oak file. The Berkeley file is operating impaired and driving on a suspended, I think. Don't know what it was pled to. The other file was also operating while intoxicated and again, driving on a suspended. I don't know how far they went. The bench warrants were issued in April of 24. In one file, April 30th, and the other file, it appears that Berkeley file was for a probation violation. And it appears that the Royal Oak file it's the same. So apparently there was an adjudication.
On both files.
Yes.
Okay.
So we'll put you and Mr. Pearson in breakout room 1. Mr. Pearson, you're going to see on the screen an invitation to join a breakout room. Please
Okay.
join.
Okay.
And there'll be breakout room 1. You should be seeing it on your screen just about now.
Good morning once again, everybody. Happy Tuesday. It's TCF Live. So, slower start this morning in the courts. They're just starting to come online now, so we'll keep an eye, but we're going to ride with the magistrate for a little bit as things get moving here this morning.
Kennedy, this is citation 26 BE02528. You were cited on the 19th of May at about 4 o'clock in the afternoon for disobeying a traffic control device in the area of 12 Mile and Tyler. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Admit responsibility explanation.
And what is your explanation, please?
As I was driving, I went through the light as it was changing. I just didn't really feel like slamming on my brakes right in the middle of downtown Berkeley.
How bad a slam is it on your brakes if you're going less than 30 miles an hour?
Well, just, I guess, I don't know. I didn't mean like slam like I was going super fast, but slam in the sense that I just didn't want to skirt.
Yellow means stop. Solid yellow means stop. It does not mean caution. It does not mean slow down. The light is yellow for 1 second for every 10 miles per hour of the speed limit. Speed limit there, I believe, is 30. So the light was amber no less than 3 seconds. You see it turn red, you should have stopped 200 feet before. You rightly admit responsibility. Is there anything you want to add to this, Officer Fedison?
No, sir.
The fine on the ticket is $130. The Secretary of State, let me check your record for one reason. Okay, the Secretary of State is going to send you a letter. You still live on Violet Street?
Yes, sir.
Okay, they're going to send you a letter to tell you how you can take an online traffic safety class. It's a once in a lifetime opportunity to stop
Okay.
the points from going onto your record.
Okay.
It's a Secretary of State program. It's automatically happens. You don't have to do anything to initiate the process. The
Okay.
points do not go on until you've had a chance to take that class.
Okay.
So the class doesn't take the points off. It stops the points from ever going on.
Okay.
And that is based on the fact that this infraction is 3 points or less, not including careless, and you have a good driving record, which they define as 2 or 3, less than 2 or 3 points, but it's a once in a lifetime. So you are good to go today. You can pay the $130 online or by mail, or if you choose, you could stop by the courthouse and pay it at the counter. It's totally up to you.
Okay.
And that's the good news. Okay. Thank you.
Thank you, Your Honor.
Have a good day.
You too.
See what iPhone Judge is. Screen name iPhone Judge. Please unmute yourself. What is your
Hello.
name?
Hello, my name is Rebecca Hutchins. I'm helping my mother, Rosemary Hutchins, for her court hearing. She's right here, Judge.
46 agreement.
This is a
Get my hearing aid out.
this is an arraignment. Okay, we'll bring in, prior to the arraignment in this matter, your mother is going to have the opportunity to consult privately with an attorney in a breakout room. And the breakout room will show on your screen in just a moment. You should be seeing it right about now, an invitation to join.
Okay, let me
Wait a
do
minute.
it. I got it.
Join.
I got it.
And then Ms. Cole, Attorney Cole will be there shortly. You're on the docket, so she sees what it is. So we'll just put it there.
I am here.
Okay, as is Ms. Hutchins.
Okay, very good. Thank you.
Thank you. It looks like we've got Mr. Pearson back and Mr. Gonzalez. These are files 23-01973. This is the Royal Oak case, People of the City of Royal Oak versus Dante Maurice Pearson. The other file is 23-02005, People of the City of Berkeley versus Dante Maurice Pearson.
Good morning, Your Honor. Juan Gonzalez appearing on behalf of Mr. Pearson, who is present via Zoom, also consenting to having this hearing via Zoom, date and time set for an arraignment on 2 bench warrants. We would ask the court to recall both bench warrants, reset both these files for a violation hearing. At this time, my client is declining MADC services, indicating he's going to retain his own counsel.
You here consenting to doing this on the Zoom platform?
That's correct.
We call the bench warrants. Reset the hearing. That leaves us with bond.
Your Honor, my client has turned himself in. He is aware of the bench warrants. I believe he doesn't have any other warrants or holds. He apologizes for not completing the probation. He is 25 years of age, lives in Oak Park, single, working some odd jobs right now. Just ask the court to consider a personal bond because he's turned himself in with the standard conditions.
How has he known about the warrants?
How did he know about them?
They came in the mail like a week or two, like 2 months, like a month ago. Like they started sending like these little cards, like it's like a short card that was coming in the mail.
The warrant's been outstanding for over 2 years.
2 years, that's what I seen too.
You knew this didn't just go away. When was the last time that you were tested for alcohol consumption?
It's been a long time.
What would happen if you were tested today?
I'll be okay. I can test right now.
Let's see what the number of testings per week. You were sentenced to 24 months of reporting probation. The terms were to run concurrent between the 2 files. Any violation of these orders may result in up to 93 days in jail for counts 3 and 4. You were on a scram tether and you removed it without permission.
He turned it in, but yes, he did.
I
That is correct.
didn't cut it off, but I did turn it in because I couldn't pay for it no more. I just couldn't pay for it. I was paying $300 a month on that, and it was on bond conditions. And then once I got on probation, My probation
Mr.
officer.
Pearson, you can wait at your hearing. That's when you want to talk about that.
Okay, all right.
So rather than coming and telling the court you couldn't afford to do it, you did it on your own, and then you wait 26 months to decide to come into court when you feel like it. Do you have a driver's license?
It got revoked when I got into this.
How did you get here today?
With my auntie.
The only thing you've got going for you is that the fact you came in voluntarily. Had you been brought in shackles, wearing handcuffs, the bond would be just what it was set by the court 2 years ago plus. You've come in voluntarily. Did you bring the bond money with you?
Auntie, that's it.
Say what?
I said, no, I didn't.
What did you bring?
I just brought my auntie, that's it.
How much money did you bring?
I didn't bring no money.
None?
Mm-mm.
Bond on each file will be $1,000 cash, surety, or 10%.
$200, sir.
Good morning, Mr. Gonzalez. How are you?
Doing well. How are you?
Good. And good morning, Officer Fedison, if I said that right.
Yes, you have.
See you. Oh,
We do not have Mr. There's an iPhone, so let's see who the iPhone is.
I guess he's done with the one case now. Anyways, good morning once again, everybody. TCF Live on a Tuesday. Got some options starting to open up for other places to go now. Oh, this guy's back on the screen. Are we done or not? I'm so confused. Let's move on. Because he said his bond. Newaygo County, Michigan, Judge Springstead.
4FH, People State of Michigan versus Amanda Lynn Steffes. Ms. Steffes is here for sentencing. Prosecution defense was a pre-sentence investigation report timely made available to you.
Well, Your Honor. Yes, Judge, it was.
And Mr. Price, I'll give you the opportunity to read the report and discuss it with Ms. Steffes.
I have, Judge.
Do you have any additions, corrections, or challenges?
I do. On the first page, the case number that they listed was 2613704, and it should be 25, I believe, should be the case number.
Yeah, that's what I have in my file is 25. Okay. All right, anything else?
On that, we find the report accurate, Judge.
Is there anything that you'd like to say on her behalf?
Yes, Judge. Her minimum guidelines are 5 months. We're asking the court to consider sentence under the minimum guidelines or credit for time served. She hopes to get released as soon as possible, get out so she can be with her family. She has lifelong family ties.
in this area and in the community. She wants to get out and get back to work, Judge, so that help support her family. She has 3 children.
All right, and Ms. Steffes, have you had the opportunity to read the report and discuss it with Mr. Price? Do
Yes, Your Honor.
you have any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Yes, sir. Let me see.
You can if you want to. You can sit. It doesn't. Judge is okay if you sit. It's up to you.
I know that my last name is no good. Like, you make it clear that you don't like my last name every time I see you, but
Why do you say that?
every time I see you make a comment about my last name. In Washington County, you said that my last name's no good in that county, and here you said Steffes is from Washington County. I'm very familiar. I don't think that's fair that you put me with them. I'm a lot different than the Steffes, but I know it doesn't look like that, but I got in trouble one time 6.5 years ago, and I've not been in trouble since. I was with somebody who was committing a crime, and I was not with him when he checked out, when I found out that he was stealing. We got into a fight. If you watch the videos, which I don't think you did, but if you did, you would clearly see that I was crying on the video, and I ended up leaving the store. I don't know. I have a job right now. I don't know if I'm gonna be able to have when I get out. I work with the building inspector of Washington County. And I've had the job for a few years now, and I've done great ever since I got in trouble 6.5 years ago. I'd like you to take that in consideration, please. I've lost my home since I've been here, and I don't want to lose anything else.
So I'm confused, Ms. Steffes. You said that you were in trouble 6.5 years ago, but I see the conviction for driving license suspended 2021 out of Washington County conviction. I see larceny $1,000 more but less than $20,000, malicious destruction of property $1,000 more but less than $20,000. That was pled to larceny $1,000 or more. That was in Montcalm County in 2021.
Okay.
Retail fraud in the second degree, 2022, here in Nuevo County. And then I see this offense in 2025. So explain to me how you haven't been in any trouble in the last 6.5 years.
Okay, sorry, 6 years were the two other, the fraud for, or the larceny charge or retail fraud, 2022. I don't know what that is. I've never been charged for, retail fraud here in this county, never. Not once. I've discussed that with Price up in the very beginning of this case. I don't know what that is, but I've never been charged with, retail fraud, ever.
Mr. Zera?
If you give me just a minute, Your Honor, I'll look at her name. So I have a PSI here from Montcalm County from 2022.
Correct.
And that was for larceny $1,000 or more, but less than $20,000. And what was the date on the?
Well, the offense date was allegedly August 7th, 2022 out of Fremont PD. She was arraigned apparently August 22nd, 2022 at a PR bond, failure to appear for plea and sentencing October 12th, 2022, and a bench warrant was issued. It's listed her as being on probation at the time of the retail fraud in the second degree here in Nuevo County.
That is correct, Your Honor, and that's confirmed by Lynn. I have it right here. Exactly what you just told me.
Okay. Mr. Welber?
I see it as well. I scored it, Your Honor. I mean, I don't know what the circumstances were, but I do see it on the criminal history.
If that were the case, then wouldn't I have a when I have a warrant for a failure to appear?
I don't know.
I mean, if somebody doesn't go to court, they get a warrant for failure to appear, right? It's sitting here, you guys sitting here telling me that I had court that I missed and I never went to, but I don't have no warrants for it.
It also says that you were that you pled on December 12th, 2024. So initially failed to appear, it says that you were sentenced.
I came here for a booking fee, Your Honor. It was in front of Judge Drake, and he dismissed it. It was a booking fee.
Okay. What were you booked for?
Well, it's for retail fraud.
Okay.
But and again, okay. Okay, Your Honor, I'm sorry. It looks bad because same situation. I was with the same guy, and well, he was stealing from Walmart. Like, he stole a canoe.
Okay, so you know something about that.
Yeah. That's why we had to get into a fight about it in the store. When I realized that he was stealing, I ended up leaving the store. Well, after we got into a fight about it.
All right, anything else that you want to say, man?
No, sir.
Okay, Mr. Walburn, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Our guidelines are what I indicated to the court. We just asked the court to comply with the terms of the plea agreement.
Well, you know what we can do, Ms. Steffes? It sounds like you're really saying that you're not guilty of this offense. Like you didn't know that he was stealing, and it was all kind of a surprise and shock to you.
I was gonna take it to trial, but I'm not gonna take a chance on going to prison.
Okay.
Especially, and honestly, if you want the truth, the reason why is because of my last name. Because every time I see you, you make a point to say something about my family. And I got scared, and I won't take it to trial because of that reason. I just want to get this over with, Your Honor, please.
I don't want to sentence somebody who thinks that they're not guilty.
Would you please sentence me? I didn't want another felony on my record. I'm trying so hard to pull my crap together.
What you're telling me doesn't is inconsistent with what the report says that somebody observed on video.
Yep.
I mean, what the report says is that you and Nicholas were going through the store together, selecting items, and then it specifically says that they went to the lawn and garden department where the pair could be observed as they removed security devices and concealed devices under a pallet of merchandise. Was in the secluded area. Amanda Steffes could clearly be observed as she opened the top of the cereal box and looked inside the box. Nicholas then pointed to the security camera and then exited the aisle.
No, I remember exactly that moment. I was bending over looking at something, and I remember looking up, and it doesn't matter, John. I remember looking up and seeing that the box was open. And I walked over and I opened it up and I seen what he was doing, and that's when we got into a fight, and that's when we ended up leaving the aisle because we got into a fight. And then we moved on to different aisles, and we're in the Christmas department, and we were arguing about it still. I ended up crying, and I was walking away, and I got to the phone with my kids, and I was walking back and forth talking to my children on the phone. And then I ended up, I don't remember everything clearly, it was a while ago, but I ended up leaving the store. I just want to get out and not lose my job and be able to put my crap together. I know you're not going to give me time served, but I beg you to not give me the recommendations either.
Right. The Advisory guidelines would suggest a sentence between 5 and 23 months. The court's can exercise my discretion, sentence consistent with the advisory guidelines. Not consistent with the plea agreement in this case, it'd be the sentence of the court. This defendant served 7 months in Nuevo County Jail. I'll give her credit for the 108 days that she's already served. There's a $68 state cost assessment, $130 Crime Victims' Rights Fund fee. There is restitution that's going to be joint and several with Nicholas Gale in the amount of $1,498.22 payable to Walmart. The court is going to place you on probation for 2 years. There's a $30 per month probation oversight fee for regular probation, $60 a month for electronic monitoring or tether. The areas that would be addressed appear as highly probable under the core compass needs scale. And Ms. Steffes, regardless of your last name, you will be treated fairly. You have been treated fairly. And if you violate your probation, as you've done in the past, you are then looking at prison. The first thing that you need to do is stop all the nonsense, quit lying to yourself, quit trying to lie to the court, and own what you did and own the decisions that you made. If you can do that, then you can start to change your life. If you don't do that, you're going to say, Judge Springstead wasn't fair, the lawyer wouldn't fight for me, the security people lied, I got tricked, I got duped, or whatever, but you need to own your decisions. And I don't think that you're going to do that. I think you're going to be back again.
I'm sorry you feel that way.
You do have the right to make application for you to appeal your conviction sentence. If you cannot afford an attorney, the court appoint an attorney to represent you on appeal. Request a lawyer to file in the court within 42 days. You also have the right to petition the court for an early discharge of probation. If you successfully complete half your term, the court will give you 90 days from your release from jail to pay your financial assessments.
3 months and get good time. Good time also. So take that one with you if you're going to file an appeal. You have to fill this out and get back to the court. Okay.
Thank you, sir. Thank you, Your Honor.
Good luck to you.
So, friends, Nuevo County, where Judge Springstead is, it's not a whole lot different from St. Joseph County, where Judge Middleton is. Smaller communities. He probably knows the people. So when he says you're going to be back, which he just did to her, he's got a history and he knows her. I hope she proves him wrong, but, you know, this is a community where the judge is probably going to be more connected than most, so he knows the patterns. So hopefully she can rise above. Anyways, let's go to Florida. Wade Mercer.
Mr. Ricardo, if you please introduce yourself to Mr. Flores and make sure he can hear you, please.
Very well, Your Honor. Muy buenos días, señor Flores. Mi nombre es Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me escucha bien?
Sí, señor.
He can hear me, Your Honor.
Great. Mr. Flores, you're being brought back up this morning to advise you that you now have a hold from the United States Immigration Service.
Señor Flores, se le está trayendo de vuelta para notificarle que ahora tiene una orden de retención de parte del Servicio de Inmigración.
So if you post bond, be aware that you will not be released. If you post bond, you'll be released into the custody of the immigration agency.
Entonces, dese por notificado de que si paga la fianza no se le va a dejar salir, sencillamente pasaría a estar bajo la custodia del Servicio de Inmigración de esa agencia.
And this does not necessarily mean that you'll be deported. It means that they want to take a look at a closer look at whether or not you need to be deported.
Y esto no significa necesariamente que lo van a deportar, significa que quieren investigar más de cerca si lo quieren deportar o no.
If you don't post bond, you'll deal with your local charges in Jackson County and deal with this issue later.
Si usted no paga la fianza, entonces se encargaría de su cargo en el condado Jackson y se encargaría del caso de inmigración en el futuro.
Do you have any questions?
¿Tiene alguna pregunta?
Sí.
Yes.
Para mirar a mi abogado, necesito localizar a mi familia, pero no tengo ni un número de teléfono. Cuando me agarraron, no me dejaron traerme nada.
Yeah, to get in contact with my attorney, I need to be able to reach out to my family, and when I was caught, I wasn't allowed to bring anything.
Your Honor, I can sort of help out a little with that.
Y dice la fiscalía, su señoría, yo puedo ayudar un poquito con eso.
Quiero localizar a mi esposa para que me puedan solicitar un abogado. Llegué aquí el viernes, pero no tengo comunicación con ellos porque no tengo ni un número de teléfono para que llamarle, y quería saber si me hacen favor de comunicarme con mi familia, o de que me pasen un número de teléfono para poder comunicarme con ellos, para explicarle qué es lo que está pasando aquí, y que me expliquen ellos también allá qué es lo que, si me van a echar al abogado, para que me echen un abogado.
Yeah, I want to be able to reach out to my wife so that she can get an attorney for me, but I don't have any phone numbers. So I was wondering if you might be able to help me out so that I can reach out to them, let them know what's going on in here, and then they can let me know whether or not they're going to be able to get an attorney for me.
Mr. Mitchell.
Your Honor, I have been in touch with Madeline McLaren since yesterday afternoon.
Su señoría, yo he estado en comunicación con Madeline McLaren desde ayer por la tarde.
She has been in contact with me regarding Mr. Flores, and she is going to, on his behalf, reach out to his family to get in contact with them.
Ella ha estado en comunicación conmigo referente al señor Flores, y ella, a nombre del señor Flores, se va a comunicar con la familia de él.
Who is Madeline McLaren?
¿Y quién es Madeline McLaren?
She's from Gunter and McLaren Law, Panama City attorneys.
Es de la oficina Gunter and McLaren Law, de una oficina o bufete de abogados de Panama City.
So they have been hired or in the process of being hired? Is that why they're involved?
Así que los contrataron o están en proceso de ser contratados, por eso es que están envueltos.
From what Ms. McLaren has told me, they may be representing him in the future, but they haven't filed a notice of appearance, but they're not repping him at first appearance for today.
De acuerdo con lo que me dijo la señorita McLaren, puede ser que en el futuro lo estén representando, pero todavía no han presentado la orden de comparecencia a su nombre y no lo están representando en esta audiencia.
But nonetheless, she said that she will pass this information on to his family so that he can be accommodated.
Sin embargo, ella dijo que sí le va a pasar esta información a la familia de él para que él pueda recibir esa acomodación.
So, Mr. Flores, anytime your bond changes, you have the right to use the phone to contact friends or family?
Señor Flores, cada vez que su fianza cambia, tiene derecho a comunicarse con sus familiares o amigos.
So you'll get to use the phone in just a few minutes.
Así que en solo unos minutos le permitirán usar el teléfono.
I have no way of giving you any phone numbers. There's no way I can deal with that. That's nothing I can fix.
Yo no tengo forma de darle números telefónicos. No es algo con lo que le pueda ayudar. No está en mis manos.
Do you have any other questions?
¿Tiene alguna otra pregunta?
Sí, si alguien ha llamado, si me puede ayudar, si alguien va llamado aquí, Jackson, preguntando por mí, que me pasen el número de teléfono para poder yo comunicarme con mi familia.
Just to get help, if somebody calls here reaching out to me, if they could get a phone number so that I can call my family.
Okay. All right. Thank you. Have a good day, sir.
Bien, gracias. Que tenga buen día, señor.
Thank you, Mr. Ricardo.
Thank you, Your Honor. Have a good day.
You too, sir. We do have two people, Mr. McDaniel, that have friends or family here. The first on the list is Hayden Johnson. Mr. Johnson, your grandfather and now your mother are both in the courtroom. Mr. Johnson, you're being brought back up today. You first appeared last week on the charge of battery. I want to ask that you listen to Mr. McDaniel and we'll see where we stand.
Your Honor, we're going to ask the court for a possible conditional release for him to go to Chrome, ask to go ahead and arraign him and place him on the August 19th court docket if the court pleases court.
Thank you, Mr. McDaniel. Mr. Mitchell.
Your Honor, I actually was, and I just remembered this. I was looking at the docket yesterday, and I was told he was going to be arraigned on this today. But I actually was planning on sending out a probation offer for Mr. Johnson with the condition that he enroll in and complete inpatient drug treatment. If we wanted to arraign him today and see if he wants to accept that offer or recommended disposition.
Let me go ahead and arraign him. What I'm going to do, Mr. Johnson, is let's get you an attorney appointed and let you talk to the attorney in private about that possibility. Mr. Johnson, would you like to have an attorney appointed to represent you on this battery charge?
Yes.
Okay, I'm going to appoint the public defender's office to represent you. I'm going to schedule you for the arraignment docket, or actually the next case docket, Mr. McDaniel, of August what? August the
August 19th, pre-trial,
right.
and enter plea of not guilty. And I don't know if the family wants to cooperate or do anything. I know they had called me prior and was trying to, I don't have no problem if he wants to take probation, but I know the family was very much against it, and they were,
But the email, I'm sorry, go ahead, Mr. McDaniel.
They just did not want to go forward with it, and they were trying to, fight me about him getting any convictions, and so I don't know how they're gonna feel about it.
I got a place I can stay that's not there though.
Okay, we don't have to deal with that today, but the email I got yesterday said that, or maybe the day before yesterday, said that he may be going to Chrome on a conditional release. Is that still something we're looking at?
Correct. That's the only thing I'm asking right now, just to, send him to Chrome August 19th pre-trial, and we'll, look at these other things later.
Okay, so Mr. Johnson, you need to understand, if I do grant you the conditional release, which I don't necessarily have a problem with, and you go to Chrome Inpatient Drug and Alcohol Treatment Facility, that you have to stay there. And if you leave there, that will violate your conditional release. And if that happens, you would go to jail with no bond. Do you understand that?
Yes, sir.
And you do want to go participate in that drug and alcohol treatment program. Is that correct?
That's still the next court date possibility of probation. Oh, yes, sir.
Well, the probation offer that Mr. Mitchell just mentioned said with inpatient drug treatment. So this would be part of his offer anyway. Is that right, Mr.
Yes,
Mitchell?
this would be part of his offer.
Yeah, so this would be part of his offer anyway. So we're not going to resolve the case today. If you don't want to, that's fine. But we want to try to get you to inpatient drug treatment if that's what you want, if everybody's in agreement on that. Mr. Goods?
Yes, sir.
Would he be going today, Mr. McDaniel?
Yes, Your Honor. Yes, sir. I think the Chrome, they're ready for him. I didn't talk to him today. I talked to him last week, but they were ready for him last week, so I suspect he's going today. Yeah.
Okay, so if you grant the conditional release, I guess we'll waive the COS and waive the calling in of the check-in monthly. The only condition would be he would agree to go and complete inpatient drug treatment at Chrome, and he would go today, correct?
Yeah, and then he would come back to court when he gets through with the program, and we'll see where things stand, see what the state's position is then.
Yes, sir.
So when you finish the program, the state, Mr. Mitchell, may decide to dismiss the case at that point. I have no idea. We'll have to see, but you've got to complete the program as step number one.
Yes,
Mr. Mitchell, is that all agreeable with the state?
That is agreeable. Completing the program is at the top of our priority when it comes to our recommended offer.
Does the family have any questions? No questions?
Did you want me to put him on that pretrial docket August 19th, or just to put it on?
Just a second. Let's see if the family has any questions. Do you have any questions, sir?
My understanding is that he's going to Chrome for 30 days.
No. Chrome is a 6 to 9 month program. 6 to 9 month inpatient drug treatment program, not 30 days.
I think it's 9 months.
Is it 9 months?
9 months
Okay.
plus after.
It was 6 months, and then it was 6 months, and I think they've lengthened it to 9 months, and then within the last 6 months, they've lengthened the program. So Mr. McDaniel knows much more than I do about that. Any other questions?
Really what I'm talking about. I was thinking it's gonna be 30 days before something else.
No, he's gonna go to the program, he's gonna stay, and he's gonna finish it. And if he leaves the program, I'm gonna put him in jail with no bond.
Yes, sir.
All right, Mr. Johnson, that's what you want to do, right?
Yes, sir. Thank you.
I wish you the best. I want you to do well. I want you to complete the program. We're gonna grant you the conditional release. What's gonna happen regarding the conditional release, Mr. Goodson? Does he need to come here?
Yes, sir. If the jail wouldn't mind bringing him this morning, I'll instruct him. They can carry him back, get him ready, and he can go today if that's okay.
Okay, so Mr. Goodson's got to go over the terms of the release with you. He'll do that in person at the courthouse, then they'll take you back to the jail. They may take you from the courthouse straight to the program, but
Yes,
you're
sir.
hopefully going to be in there today. Mr. Johnson, I wish you the best. Just take it seriously and complete that program, okay?
Thank you, Judge.
Yes, sir. Wish you the best. Thank y'all for
Just to
coming.
clarify, you want him on the inactive docket or the August 19th docket?
Whichever one you're requesting. I'm sorry, Mr. McDaniel, August 19th is fine. We'll put him on August 19th. And let me tell you something about that to your family too. If he's still there on August 19th, we're not going to stop treatment just to bring him to court, to just continue to another court date. If he's still there, Mr. McDaniel's going to stand up and say, Judge, he's still in treatment program. Please pass this to another court date. And Mr. Mitchell, if they're doing well in the treatment program, Mr. Mitchell always agrees. Okay, so you're giving you a court date of August 19th, but if you're in that program, you're doing well, we're not going to bring you out of the program for a court date. Any questions?
Yes, sir. No, sir. I just want to tell my family there I love them.
Thank you.
As far as there's no contact, I don't.
The no contact order still in effect. Yes, ma'am.
If he completes the program.
If he completes the
there's a
program, Mr. Mitchell will evaluate it, and sometimes he will dismiss the case. That'll be a decision he makes.
That's why I say there's a possibility. So,
Okay.
Get out of rehab for sure.
It's a year from now, so you got a long time.
Okay, we do have one more person that has friends or family here, Mr. McDaniel, and that's Samad Johnson. Mr. Johnson, good morning, Mr. Johnson. Your sister and your mother are both in the courtroom. You're here for first appearance. Accused of one count of aggravated battery, one count of false imprisonment, and one count of misdemeanor assault. It looks like you got out of prison in September. Mr. Johnson, so I'm prepared to set your bond in these cases because I think you're entitled to a bond, but listen to the attorneys before I address that bond. Mr. McDaniel, anything on behalf of Mr. Johnson?
No, Your Honor.
Mr. Mitchell?
no, Your Honor.
Mr. Johnson, based on your criminal history and the charges you're accused of, your bond is $25,000 on aggravated battery charge, $10,000 on false imprisonment charge, $5,000 on assault. Your total bond today is $40,000 cash or surety. You have a condition of absolutely no contact with the alleged victim at all, but you do have the right to the bond because you're not on any probation and you have no charges pending as far as I can tell. So, ladies, his bond is $40,000 cash or surety because he just got out of prison 8 months ago, 10 months ago, and because this is a very serious charge, part of which was captured on the security camera at the hotel, according to the complaint. So according to the complaint, he struck her a couple times. That was captured on video. Be aware of that. Does the family have any questions?
What is cash or surety?
Cash or surety means there's two ways to post a bond in every case. One is to put up $40,000. The other one is a surety bond, which is called, that's what you go through a bondsman. If you decide to post a bond for him or go through a bondsman, that's a surety bond. By Florida law, they have to charge you 10%, but sometimes they'll take 5% up front and 5% later. I've heard of that happening. So what they charge you, that's something you talk to them about, but by law, it's set at 10% of the bond. Yes, ma'am.
She is pregnant and she's going through the motions with dropping the charges or something.
She can ask the state attorney's office to drop charges, and the state attorney's office will make that decision. One of the factors they'll look at is his prior criminal history. He just got out of prison for shooting somebody in the head or in the neck. So,
Man, I wouldn't go to prison for that. I went to prison for DOP.
yeah, he was on probation for that. Well, he pled to it, so he was sentenced to prison for 4 years for it. So I think we're past allegedly. Do you have any questions, though, ladies?
Well, I do.
Okay.
The young lady is pregnant.
Right.
I mean,
Judge, you might want to caution them about anything that's said right here is on the record, and I also will take account of what's said too.
If you have a question, I'll try to answer it. But his history is bad. You understand, someone's from his prior case, the rest of their life is different because of something he pled to and was sentenced to prison for. He gets out of prison in September, and in June, he's charged with another crime of violence. That's the situation he has.
But you said no contact with her.
Absolutely no contact. Even if she wants contact, I'm not going to allow it because the allegations are he endangered the child. So I'm going to protect that child regardless of what she wants. Okay. So if she wants contact, that may be the confusion. If she wants contact, it's not going to happen anyway. I'm not going to allow it. Okay. Because the allegations are he hit her in the stomach, and I'm going to protect the child, period. From her as well as him. Okay. Thank you. Thank y'all for coming. Your family said they love you. Mr. Johnson, we also want to ask the court to give you a notice for your court date. That will be when, Dawn? July the 7th at 8:30. Mr. McDaniel, anything else in Mr. Johnson's case?
No, Your Honor.
Thank you. After Mr. Johnson, we have no more friends or family in the courtroom, so we can go back to the top of our list, which is Christopher Smith. Mr. Smith, good morning. Mr. Smith, you're here for It's like you were held 7 days on the violation of probation hold, Mr. Smith. I looked in the file this morning and Judge Garcia did sign a no bond warrant in your case. I believe it was signed yesterday. What I'm going to do, Mr. Smith, is I want to get you arraigned today because I want to get you a lawyer appointed if that's what you're wanting. Mr. Smith, would you like to have an attorney appointed to represent you in the VOP?
Yes,
All right. All right, Mr. Smith, I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and then I'll see if you have any questions in just a minute.
Your Honor, we're going to plead not guilty, yes, sentence on July 7th, pretrial docket, and there'll be an attorney that'll come by, hopefully, and speak to him, but if not, they'll speak to him on July 7th and one gets assigned.
July 7th.
It's July 7th. His a new law felony, so it's going to be on the same day.
July 7th. And Mr. Mitchell, anything from the state?
No, Your Honor.
So July 7th is your court date, Mr. Smith. Do you have any questions, sir?
So no way of getting out today. It's gotta wait until July 7th.
Yeah, you've got no bond signed by the circuit judge. You got to see that judge before you're going to get out. All right, have a good day, sir. We have Keandre Riley next. Mr. Riley, good morning. Mr. Riley, you're here because you've been accused of 3 new charges and you have 2 violations of probation. So the new charges are felony battery, felony criminal mischief, and petty theft. There is probable cause for those charges. Then you have a violation of probation warrants in 23-558 CF and 25-412 CF that have no bond on them. Now, those warrants were dated before the new charges. So they very well may be modified, but they had no bond before they were even accused of the new charges. So what I'm going to do is I'm going to set your bond in the new charges, but I'm also going to address the VOPs, which have no bond on them, and we'll do that after hearing from the attorneys. Mr. McDaniel, anything I need to be aware of other than that from Mr. Riley?
No, Your Honor.
Thank you, Mr. Mitchell.
Your Honor, I think the petty theft is a felony petty theft, at least according to the warrant, because it says petty theft, 2 or more prior convictions.
You're right. It is. Thank you for clarifying that.
But other than that, not just standard conditions, no contact.
Thank you. So, Mr. Riley, let me go ahead and set your bonds. Your bond's going to be $10,000 on each of the felony charges you're accused of. That's felony battery, felony criminal mischief, felony petty theft. So your total bonds today are $30,000. Do not try to post them, Mr. Riley, because you wouldn't get out anyway because the circuit judge has set you no bond in the VOPs. So you've got no bond in 2 VOPs. Now let's move on to the VOPs, the violation of probation cases. I want to arraign you and get you a lawyer appointed if you're asking for one. Would you like to have an attorney appointed to represent you in the violation of probation cases?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and we'll see if you have any questions about that appointment in just a minute. Mr. McDaniel.
Your Honor, we're going to plead not guilty, yes, sentence on July 7th, pretrial docket, and I advise him there'll be an attorney that'll come and speak to him, or they'll speak to him on that day on July 7th.
Thank you. I don't know if I said no contact in the new charges, but there's a condition, no contact with alleged victim, July 7th, court date in the VOPs. Mr. Mitchell, anything else I may have missed?
No, Your Honor.
Mr. Riley, do you have any questions, sir?
No, sir.
Well, Mr. Riley, wish you the best, sir. Duchess Kirkland. Ms. Kirkland, good morning. Ms. Kirkland, you're here for first appearance for a holdout of Holmes County, Florida. Ms. Kirkland, the information we received from that sheriff's department says they have a no bond warrant for you there. Ma'am, they would like you held with no bond, so you're going to be held for Holmes County. They may get you today. They may pick you up the next day or 2. When you do go to Holmes County, ma'am, you'll go to a first appearance judge there, and that judge will address your bond status. I can't tell from the paperwork we have if you're going to get a bond when you get over there or not. Looks like you might. Mr. McDaniel, you couldn't open the warrant either, could you?
It's violation of state probation.
Then you're probably not going to get a bond, but that'll be up to that judge. Right now, you have no bond, Ms. Kirkland. Do you have any questions?
No, sir.
All right, ma'am. Wish you the best. Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Thank you for getting Mr. Johnson up. I appreciate the way you stay on top of your cases. That's makes our system a lot better. I appreciate that. Corporal Campbell, anything else in the jail?
No, Your Honor.
Dawn has just handed me the capias on Richard Lyons. Mr. Lyons was supposed to turn himself in yesterday morning by 8 a.m. He did not do so. I've asked Sergeant Applewhite to see if they can find Mr. Lyons and give him a place to stay till I can see him. I'll file a suggestion of contempt. We'll see. I know he's entitled to a bond in those cases, Mr. McDaniel. We will see if we go through that process. It kind of depends on how long it takes to get him and what his reasoning is for not turning himself in. He may have a good reason. I have no idea. Mr. Mitchell, anything else today?
No, Your Honor.
I've asked them to, quote, find Mr. Lyons and see if they have a place for him to stay until I can speak with him. It's very interesting language. Good morning once again, everybody. TCF Live on a Tuesday. Getting to the end of hour one. Let's go back to Newaygo County and Judge Springstead. New contestant there.
Joseph Alexander Scheller. He's got two files, 2613755 and 2613757. He's here for a pretrial conference on both of these matters. And Mr. Walburn, is there an offer that the people are making?
Yes, Your Honor. The defense going to plea to one count of possession of meth, habitual second. It doesn't matter to me which one. I think Mr. Prysock indicated he was going to plead to the more recent one. The balance of the charges will be dismissed, Your Honor. On one of the files, a knife was seized. I believe it was on 13757. As part of the plea, the knife will be forfeited to the police. A sentence within guidelines, Your Honor. 0 to 21.
All right, Mr. Prysock, is that your understanding of the offer in this case?
It is, Judge. He would enter a plea to 26-13757. I believe that's the one that occurred on May 1st, 2026, because the other one was later in time, back in, I think, October of 2025. So we'd enter a plea to the more recent charge of possession of methamphetamine habitual second.
All right. Is that what you want to do, Mr. Scheller?
Sure.
Raise your right hand, please. You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. So the charge that you're entering a guilty plea to reads as follows. Said on or about May 1st, 2026, that you were in Big Prairie Township, Newaygo County, state of Michigan, and that you did knowingly or intentionally possess methamphetamine. This is a felony which carries up to 10 years in prison and or $15,000 fine plus cost. Do you understand the charge and the maximum penalty? You'd also be pleading to as a habitual offender second, which means that you have at least one prior felony conviction. What they've listed here, that you're convicted April 21, 2014 of unarmed robbery here in the 27th Circuit Court for Newaygo County. Do you have that prior conviction, sir? You have to speak out loud.
Yes, sir.
All right. With the habitual offender second, it makes it possible that you could be looking at 1.5 times the maximum sentence, which could increase this felony to 15 years and or $22,500. Do you understand how the habitual offender second could increase your maximum penalties?
Yes.
Yes?
Yes, sir.
All right. You have a plea agreement such that if you enter a plea, if you successfully plead to that, they're dismissing count 2 in that file, which would be driving while license suspended second and 1-year misdemeanor. Do you understand that?
Yes.
And they're also dismissing file number 2613755, which also is a possession of methamphetamine with habitual offender second. That's going away. Do you understand that?
Yes.
You have a sentencing agreement that should be sentenced consistent with the advisory guidelines. The prosecution has provided an estimate of 0 to 21 months. Your actual guidelines could be higher or lower as I score them at the time of sentencing. Do you understand that? Is that your complete understanding of the plea agreement to resolve these 2 files?
Yes,
Just speak
sir.
out loud.
Yes, sir.
Have you had sufficient time to consult with Mr. Prysock about these charges and this plea agreement?
Yeah.
Subject to the plea agreement, how do you wish to plead?
Plead guilty, right?
I don't know, I'm asking you.
Yeah, plead guilty, yep. I was making sure I didn't say the wrong thing.
All right, so you want to plead guilty? Is that what you're telling me?
That's what we talked about. Yeah, to the plea agreement, yeah.
Okay. You understand that if I accept your guilty plea, you'd be giving up the right to have a trial of any kind?
Yes.
You also understand that you're giving up the rights that you would have at trial?
Yes.
We listed those rights for you on the written advice of right sheet that you signed today. Did you read that document?
Yeah.
Did you understand those rights?
Yep.
Did you go over those with Mr. Price?
I think the other day. Those are the ones we went over yesterday. Yeah.
So yes, you did?
Yes.
Okay. Has anyone threatened you to get you to make this plea?
No.
Has anyone promised you an outcome different than what we put on the record? No. You went to this plea of your own free will?
Yeah.
Do you understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice?
Say that again?
Do you understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice? You now give up your right to have a trial of any kind and all the rights that you would have at that trial, and you still want to plead guilty. Is it true that on or about 1/2026 that you were in Big Prairie Township, Nuevo County, state of Michigan?
Yes.
Looks like you were operating a motor vehicle, is that right?
Yes, sir.
And you were pulled over by the police?
Yep.
And as a result of that police contact, did they find some methamphetamine?
Yes. They found a guy with residue in it, yeah.
Okay. And where was that located?
In the cup holder, I believe.
Is that your methamphetamine?
I was the only one in the car, so yeah, I took responsibility for it. It's mine.
Well, did you know it was there?
I really didn't know it was there, but I mean, I thought I was under the impression that when you're driving a vehicle or anything in the car, you're responsible for it. So I took responsibility for it. I didn't lie to the officer. I just said it was fine.
All right. So very simply, was this your methamphetamine?
Yes, it's mine.
And did you know it was in the car?
I didn't really know it was in the car, but I had to put it there, like what I was using. So
Okay, so you were a methamphetamine user at this time back in May of this year, is that right?
I have been for a few years.
Okay, but you were using around May of this year, is that right?
Yep.
And this was your car?
No.
Whose car was it?
It was the guys I went and picked up in the carpool, but it wasn't his car either. So I guess the car was stolen. I didn't know.
It was stolen out of Kent County. They did not charge him out of Kent County. I don't know if they charged anybody, but apparently it was stolen out of Kent County and he was found driving it here in the way.
Okay, well, Mr. Scheller. If you were just happened to be in this car and there happened to be meth in there and it wasn't yours and you didn't know it was there and it was all just a big misunderstanding, then I'm not going to take your plea in this file. If, on the other hand, you're a methamphetamine user and this was your meth and you put it in the console and you got caught, that's a whole other story.
Yes, I could have
All
put it
I
there.
want to know is truthfully,
I
what
could have put it there and
happened?
forgot about it. I could have put it there and forgot about it, yeah.
Judge, just with all due respect, I've talked to his family 3 or 4 times. He has some memory issues. He has some cognitive disability issues. So we went over the plea pretty extensively. He has
for want of a better word, a low functioning ability. Talked with his sister and his mom both, so he wants to plead guilty. That we talked about it yesterday. There's no doubt it was his method, but I mean, he just with his mental status, that's possibly the reason for the confusion, Judge. But he does want to enter his plea. Yeah.
If this wasn't yours, and you didn't know it, we could talk about the other file, and you can have the same plea in the other file.
It was mine.
Okay. Are and you also have at least one prior felony conviction, is that right? We talked about that.
Yes, sir.
Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor. They're none, Judge.
Is he competent to enter this plea?
Yes, Your Honor. He is, Judge.
Does the court comply with MCR 6.302?
I have, Your Honor. The court has.
All right, the court does find the plea to be knowing, understanding, voluntary, and accurate. The court's going to refer him to the probation department for the preparation of a pre-sentence investigation report. We'll set sentencing for August 11th at 9:40.
What was that date again? 11. Okay.
August 11th, 9:40.
Got it. All right. They're going to meet with Mr. Zerk. He's going to do a report. We'll get a copy of it.
Give me just a moment, everybody. I was in the middle of getting another courtroom set up for us when they cut that feed. Let's go here for the moment. Judge McNally, say good morning to him.
Your name? So what did she tell you she was going to give you? I'm having a hard time reading her writing. It's a civil infraction.
Yes.
What did she say she was giving you?
That's Christopher.
I'm sorry, I need to give Ms. Esmail if that's you.
Oh, I'll put the prosecutor Judge.
Okay, thanks. I'm sorry, I need your appearance.
Good morning, Your Honor. Not today, as I will have the people, the AA
Statute out here for some reason. It's not too many fish on the line, it's too many lines in the water, right?
I apologize, too many lines on the water.
I just wanted to make sure.
I apologize, I regard that. Well, thank you for the word fish because it was lifting, not fishing.
That's okay. No problem. I just wanted to double check with you. Sir, to that chart, too many lines in the water, a civil infraction, you plead responsible or not responsible?
Responsible.
Okay. I'm gonna fine you $135 total. Lisa, I don't know if that one requires a conservation fee or not. I don't think it does.
It does, but it's already added into the 135.
Perfect. Thank you. You're all set. You can go down the hall and pay that, okay? Thank you. Good luck to you. And I'm dismissing the misdemeanor. Oscar Labrado Huerta Nino 26M 690 1068. All right, Mr. Vitale, your name?
Yes, thank you, Your Honor. Stephen Vitelli, P45601, on behalf of Mr. Huerta Nino, who's here for an arraignment. He'll waive formal reading and he'll stand mute.
Sir, I need you to start your video, Mr. Oscar Huerta Nino. He speaks strictly Spanish, is that true?
I believe that's correct, Your Honor.
Do you speak Spanish at all?
Do I speak a little bit? He does. He is present with a relative of his too, also on.
Okay, well, can the relative get him online real quick for me, please?
Certainly, Your Honor. I'll text the relative right now.
Look, let's just do this. We're going to get an interpreter, right?
Yes.
Where was he? He didn't show up before though, twice. So make sure he shows up, okay?
Oh, absolutely.
I'll adjourn this for arraignment and pretrial, Lisa, till what would that be? After July the 12th, they want. So if we could do July the 14th at 9 a.m. and we'll get a Spanish interpreter here, okay, Lisa?
Okay.
So that's what I'll do. I'm just gonna go ahead and adjourn it. Sir, what is your name? Yeah, he doesn't understand me. I'm just gonna go ahead and adjourn the arraignment pretrial. And we'll get a Spanish interpreter. And you have to convey to him somehow he has to be here on July 14th at 9. Okay, Mr. Vitale?
Wonderful. Thank you, Your Honor, very much.
Now, listen, I'd prefer that he be in your well, wait a minute. I don't want to. Where's your office?
My office, Your Honor, is in Troy, Big Beaver and I-75. If you want, Your Honor, I'll bring him to my office and zoom on from there.
Well, that would be either that or you come here. It's easier if you're here with a Spanish interpreter is all I'm saying, but I'll let you do that. Either way, you either have to have him in your office or you two be here, okay?
Thank you, Your Honor.
July 14th at 9 and we'll get the Spanish interpreter. Thank you very much.
Thank you.
People Against Harvey Trucking Services, 26S118459 A and B.
Kind of a messy morning in Judge McNally's court. Let's move along. Let's go to Texas, Judge West.
Good morning. Are you Anthony Whitmire?
Yes, ma'am. Good morning, Your Honor.
And Mr. Rojas, for your client with the formal reading of the indictment.
He will, Your Honor.
Mr. Whitmire, in cause number 25 DCCR 0057, you're charged with a second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement and clause number 25 DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I gonna have to start modifying? I think I'm safe just saying it, and
It's like
then
a citizenship thing, because you can't control whether it does or doesn't.
I know.
From being readmitted.
But I mean, they've said specifically that possession is not one of them. In the Cambry case.
It really more says case by case, and I don't think it's such a blanket. I would continue to give the.
I'm gonna say, yeah, as I was saying it, it made me think. Okay, make sure you send that dismissal over on Whitmire, please, and I'll get that signed. And then as soon as hopefully they're gonna zoom in on Norris.
Mr. Ernest is a plea also, Judge, if you have it.
Okay, Brendan Ernest. Brendan Ernest. Let's see, we're going on 3 out of the 4. 2.
Everything is very long. Well, yeah.
Good morning. Are you Brendan Ernest? And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
Here we are.
Right, Mr. Ernest, and cause number 26 DCCR 0429, you're charged with the first-degree felony offense of aggravated robbery, and that's from February 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Then, let me give it a second. Cause number 26 DCCR 0430. You're charged with a third-degree felony offense of obstruction or retaliation from February 12th of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? And cause number 26 DCCR 0908, you're charged with a second-degree felony offense of robbery, and that's from February 12th of 2020. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In all 3 of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
So you can't change your mind if I follow the agreement. You understand?
Yes.
And it looks like the agreement that you've reached in all of these cases would be for 10-year deferred probations. There would be $500 fines in each case. There would be a dismissal in cause number 26 DCCR 0431, and you would be required to follow all the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Ernest is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. You've got Vicente Gloria, Mr. Rojas.
I think that was restated.
It was, okay. Who's is that? Oh, that one's what? All right, let's let me figure out how to get this done. Second. Print this Norris stuff out so that I can see the Zoom and some of the papers since I have to do it.
All right, friends, while she works to find her next contestant, let's head west from Judge West to Judge Boyd. Let's see what's going on in San Antonio.
All right, the court is calling 2021 CR 1825 State versus Christopher Eugene Garcia. Can I have parties announced for the record?
Rick Bainey for the state of Texas.
Charlie Gonzalez for the defense.
Are you Mr. Garcia?
Yes, Your Honor.
All right, on June 9th, you entered a plea of true to violation of conditions 5, 5, 5, and 5. The court found 5, 5, and 5 true. And we're here today because there was some information. You said there were some medical issues with your son, so that was going to be brought to the court.
Yes, Judge. And unfortunately, I was not able to get the HIPAA release from his ex. What I do have, and let the record reflect that I did show the state these documents. What I do have are pictures of documents if the court would like to review. I don't have anything I could admit. You are a judge.
All right, so why wouldn't his ex sign a release? Has he not been in his son's life?
He has, Your Honor, and it's and actually they get along very well. I think there was a misunderstanding of what that HIPAA release would entail. She was afraid of making documents public. That's what she explained to me, and I couldn't convince her otherwise. She just wasn't going to sign it.
All right, and here's my other question. The complainant on this case, is that the ex?
No, ma'am. On the ABI?
Mm-hmm.
It is not.
All right, how long has he been in custody?
How many?
May 20.
Since May 20th?
All right. Yeah, how many days does he have in?
Checking my notes as I process, honestly. Judge, I do have one witness.
Yes. It's a different complainant?
Wow. Sorry.
I have 40 days.
Thank you. Because this is a no contact with Garcia.
Like Your Honor, we've got credit for 40 days with this.
Okay, and then the complainant on this case, is that the same person who's the mother of this child? What's the name of the mother of the child? Okay. Oh, it's not the same person then. You say you have a witness?
Yes, Your Honor. I have his employer. It's, as I stated on the record, previously, some of the great things that he has been able to accomplish is he's lived at the same address this entire, for the last 4 years, and he's had the same employer for the last 4 years. And he did mess up, with this and not reporting, but he's made great efforts to stay stable for his son, because if you review the documents, his son may not even have 6 months left. And so he really has cleaned up his life. I think this was the triggering thing for him. And
all you had to do was report.
I understand.
And I will tell you what your attorney is saying. I appreciate that, but that's what people do on a normal basis. You understand?
Yes, Your Honor.
All right, this is what the court is going to do. The court will revoke. The court is going to sentence you to 40 days in the Bexar County Jail. Give you credit for any time served. The court will show that the judgment is satisfied. There's an affirmative finding of family violence. There's to be no contact with All right, is there anything else with regards to sentencing?
nothing for the defense.
All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, you're gonna have to make better decisions. You understand?
Yes, Your Honor.
And I will pray for your son.
Thank you,
All right,
Judge.
thank you. They should release him sometime after midnight. I'm gonna have no control over that.
Yes, ma'am. I will let.
Thank you. All right, who's next? All right, where did Trey go?
Right here, Your Honor.
Okay.
Actually, we're trying to get to the more cash. We need to go get revolvers.
All right, thank you.
Grant.
All right, friends, let's head back to Judge West. Looks like she has something racked up here.
Ma'am.
Good morning.
Good morning, Judge West.
Good morning, Mr. Norris. How are you doing?
You know who this is, don't you?
Yep, I know who you are. You're Christopher Norris, right?
Yes, Christopher Stevens Norris.
All right, so this is cause number,
Yeah.
hang on just a second. Let me go through some stuff. If you have something to say, I'll give you an opportunity, okay?
Okay.
And you should be able to see on your screen, Mr. Rojas is here, your attorney in court. Mr. Nichols is here representing the state, and this is cause number 0184078. And Mr. Norris was found not guilty by reason of insanity of the offense of murder back in February of 2006, is currently at the Russ State Hospital. And this is our yearly hearing under Article 46C of the Code of Criminal Procedure. I am going to take judicial notice of the court's file, including all of the previous hearings and reports. In addition, I have received the most recent report. I have a forensic psychiatry report to the court, which was prepared by Dr. Gerke, dated June 10th of 2026. The finding in that is that Mr. Norris, that further inpatient treatment would be recommended, and that it is not recommended that he be released to live independently at this time. And then in addition to that, I have a physician's certificate of medical examination for mental illness from Dr. Gerke. The finding in that is also that Mr. Norris is mentally ill, that without inpatient treatment likely to cause serious harm to others. And there's several notations here with some issues that have occurred between now and our last hearing a year ago. Is there any other evidence with regard to further treatment inpatient at this time, Mr. Rojas?
No, Your Honor.
Mr. Nichols? Give me just a second to, all right. Then I am going to find at this time, based on the reports, that Mr. Norris is mentally ill and that further inpatient treatment is required based on I'm sorry, I'm trying to read and talk at the same time. That he does not meet the traditional civil criteria for recommitment, but based on his current forensic type commitment, continued inpatient treatment is required because of the acquittal by reason of insanity with regard to the charge of murder, and that the specific finding is that without that, he would be likely to cause serious harm to others. And therefore, I am going to order the 1 year commitment.
No time to talk. Thank you, gentlemen. I have plenty of paper here I want to explain to you. You know that I have been locked up for 5 years, 8/13/2021 to 8/13/2026. I've been locked up 5 years. On August 13, 2026, I'll be locked up for 5 years exactly.
So, Mr. Norris, here's the thing. We tried several years back.
That was 5 years back.
Yep. And that did not go well. And so all I can do at this time is base my decision on the history and the fact that I did based on, at that time, it was everyone's recommendation that you be released to a kind of an outpatient, more relaxed situation. And that did not work. And so I ordered you back to rest.
I got paperwork showing it says, while I was at Rush Hospital, I take my meds, take all my meds, learn everything about meds and symptoms, learn my strengths and weaknesses, focus on mental health, take meds, keep appointments. I mean, I do everything that I'm supposed to be doing this year for sure. Work on my goals while I was at this hospital. I've been working on my goals. I understand that mental illness diagnosis is lifelong. Recognizing my symptoms when they are active. I mean, I got plenty. So I'm on resources, housing, transportation, food, clothing, support, medical service. I mean, I got all kind of stuff right here saying that I've been doing in the community, stay away from drugs and alcohol, stay in touch with court. I know that I gotta stay in touch with you if I get out because I know that
So, Mr. Norris, let me interrupt you real quick, Mr. Norris. I can tell you now that if the doctors are not recommending that you be released.
Yeah, I haven't talked to that doctor for almost 6 months.
Mr. Norris?
I've been asking for another doctor, and what he wrote up was 6 months back because I've been trying to get another doctor.
I've made my ruling at this time.
My
ruling is that you're going to be continued inpatient at that facility until further order of the court. If something happens and the doctors recommend some other outpatient or.
What if I don't feel safe in this facility anymore? What if I don't feel safe here no more?
Then you need to talk to that facility. I'll talk to Mr. Rojas and we'll look into it. All right. The hearing's over. Thank you.
Yeah, it's wrong though. It's wrong. That's all right.
All right. Keep doing what you're supposed to do and potentially in some time.
I have been doing what I'm supposed to be doing. I have been doing what I'm supposed to be doing.
Well, all right.
That's what I'm trying to tell you right now.
I understand. Continue to do that, okay?
So you just anything anybody else tells you, or you pull up, and it doesn't even make sense what you said about the doctor overruling. I haven't seen it for 6 months. How can you write all this stuff about me?
We'll look into that, but the report that I have is dated June 10th. And so, that's what I have to go by. And so I'm going to, again, I've made my decision.
That's gonna be
and-
your decision every time I come in front of you. I don't feel safe at this hospital.
Okay,
That's what I'm
we'll
trying to
check
tell
into
you.
that. All right, thank you. We'll check
You
into
can't
that.
check into it because you don't know how.
Thank you.
I need a button like that. Okay. See Mr. Bruce Smith? Did I see him? You've got Tajuan Mack.
Tajuan Mack.
Barbara, thank you for the $5. Cat Treat Fun. Love you, Ellie and kitties. Thank you so much.
Get ready on something else. This one, he's actually about to switch courts. So these guys, they're all going to end up split between people. Yeah, I think so. He's going to keep handling. Maybe this.
Good morning. Are you Tajuan Mack?
Yes, ma'am.
And this is cause numbers 24 DCCR 1046 and then 26 DCCR 0085 and 0086. Mr. Mack is charged with criminally negligent homicide. And then those last two are both bell jumping and failure to appears. Mr. Smith, what is the announcement?
We signed.
Oh, yep.
Rejection.
There it is. Sorry, they were just coming through. Let me go through then. All right, Mr. Mack. And cause number 24 DCCR 1046. You're charged with a state jail felony offense of criminally negligent homicide, and that's from March 10th of 2024. And what that means, sir, is that if you go to trial and you're found guilty in that case, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 26 DCCR 0085. You're charged with a third-degree felony offense of bail jumping and failure to appear from December 15th of 2025. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 26 DCCR 0086, you're also charged with a third-degree felony offense of bail jumping, and that's from January 5th of 2026. Same thing, if you're found guilty in that case, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet plea bargain rejections that you've signed with Mr. Smith that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for a 2-year term in the state jail prison on that state jail case, and then 5-year terms on the other 2 bail jumping cases, all to run concurrently or at the same time. You have every right to reject those offers and have all of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter pleas of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am.
Has everything discovery been, you've gotten everything you need, Mr. S, or everything they have as far as you know?
Yeah, Your Honor. However, just to, this court will know, due to my hospitalization, I truly believe that these cases can be moved if we can get an offer of probation. That is not the case at the moment, but that's where we're at. This is the first offender. He's eligible for probation from a jury. Right now, Mr. Coleman is only recommending print time.
Do you know, Mr. Nichols, who is this going to be yours, or are you just covering
I don't.
today?
I don't know ultimately it's going to be assigned to a judge. I know, I mean, it's a homicide case, so I wouldn't expect that part of the offer to change.
Well, except though that the witnesses are going to testify that the shooting is.
Well, that's all between y'all. I don't need to know
Okay.
what all that is. At this point, what I'm going to do is put it on the trial docket.
Okay.
Obviously, if something changes between now and then, I'd rather take care of it well before. So whoever gets assigned to the case, or if Mr. Coleman keeps the case, but either way, if something changes, then y'all let me know. We'll move the case up. Otherwise, we'll take a look at it again on the pretrial date. And then after that, we'll get set for trial.
Thank
Or we'll set up for trial now, but we'll discuss it again in pretrial.
Thank you.
All right, you go back with the bailiff.
Alrighty, friends, let's move across the hallway. See what's going on with Judge Stevens.
Present with Ms. Manaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about July 16th, 2025, in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle in a public place while intoxicated with a child passenger, a child under 15 years of age. This is a state jail felony.
Judge, I believe there's a reindictment, and she's pleading to the reindictment, not this case specifically.
It's right as the whole statute.
So the DWI indictment will be a dismissal with a plea to the new indictment for endangerment of a child.
So we've got two different cases here.
That's correct. They'll both be disposed of today.
I just have the file yet.
You don't have a file on this? Okay.
No, it's
Oh.
The reindictment
Reindicted
from
last
that
week, Judge. I don't have the new file yet.
Okay, then let's jump to 26 CR 1173. And the defendant waives a formal reading of this,
Yes, Judge.
and we proceed in summary.
Yes, Judge.
This was handed up on June 17th.
Last week, Judge.
Okay. Does the defendant waive any additional time that she may have under the law to proceed in this case?
Yes, Judge.
Okay, have you discussed this with your attorney, Ms.
Yes.
Brown?
Yes.
All right. And this is what you wish to do is waive any additional time under the law that you may have, since this was filed recently. You do have a little bit of time that you can prepare, but do you feel like you are ready to move forward and
Yes.
you've discussed this with your attorney and that is what you want to do?
Yes, sir.
All right. In 26 CR 1173, in summary,
Yes, Judge.
this indictment states that on or about July 16th, 2025 in Jefferson County, Texas, which was the same date as the prior
Yes, sir.
event. In Jefferson County, Texas, you committed the state jail felony of abandoning. It's the statute is abandoning or endangering a child, but in the charging instrument, this says that you acted with intentionally, knowingly, recklessly, or with criminal negligence, placed a child in danger by operating a motor vehicle while intoxicated and failing to secure the child in a seat belt. And you did not voluntarily deliver the child to a designated emergency info provider. So was there an accident?
No, Judge.
What is it? And the defendant did not voluntarily deliver the child to a designated emergency infant care provider under section 262.302. What's that all about? Why would that be? Arrests and engaging conduct by operating a motor vehicle while intoxicated and failing to secure the child in a seatbelt and did not voluntarily deliver the child to a designated emergency infant care provider. What happened on that? What's that all about?
But she was just pulled over in an accident.
Huh?
There wasn't an accident. She was just pulled over. Unless my memory is
I mean, is that a
mistaken.
necessary element of the offense, though, that's been alleged or not? I mean, it's just I don't get these a lot, if ever. Then it says section 22.041F, offense code 3899. I mean, there's no referral or in the indictment to what code that is referring to. I don't think it's. Yeah. But it is. Yeah.
Okay. Yeah. Right. Yeah.
Yeah. It's already alleged.
They brought her back in.
Just ending place.
Okay. And she took her views down.
That's an
Yeah. Never question what they. Let's see. Maybe, yeah, go ahead. I'm only.
But I think that we can probably just abandon that sentence.
I don't know, can we?
Under section 22.041H, it states that it's an exception of the application of this section if the child is voluntarily delivered to a designated emergency infant care provider. So I think the indictment is just alleging that she did not do that, so the exception doesn't apply. Section 22.041H. It's an exception to the general rule. I believe we can just abandon that because that's not applicable in this case. She did not deliver the child to anyone, so the exception doesn't apply, but I don't think we need to have it in the wording of the indictment to be able to charge her with this offense.
Well, I don't know if that's, I think as I'm reading this, maybe it needs to be there.
Okay, I don't think it changes
It
what
says
we're
it's an
pledging.
exception. So. But by stating did not deliver, then
The exception doesn't apply.
Section 22.041 applies. I think.
I don't believe it changes.
I don't think it does. Let's just keep it the way it is. I think so this is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty and not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 5 years in length, fined $500. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes,
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes.
Understand it? Discuss it with your attorney? Are the contents all true and correct? Yes. Okay, you have to speak out so she can hear you there.
Oh,
okay.
yes.
State's Exhibit 1 is tendered into
No
evidence without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. States Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
Nothing further. I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But the court is going to instead defer or postpone any findings of guilt so long as you follow these terms and conditions of probation. Make sure you do. You will be placed on deferred or unadjudicated probation for 5 years. If you fail to follow these properly, your probation could be revoked. You could then be found guilty and a sentence up to the full range of punishment, up to 2 years in the state jail. And that would be a felony conviction. Have you ever had a felony conviction? You don't want one. It closes off a lot of doors of opportunity. Anything else on this? Okay, please see the probation officer.
And Judge, the Hayden case will be dismissed, but paperwork has not been sent over by the state yet.
Sorry?
There's going to be a dismissal on the other case. It just hasn't been sent over by the state yet. Thank you, Judge.
Thank you. Ricardo Kelly?
Oh, ready on. There's so many there.
There's 20 minutes with Kelly.
Yeah.
You swear on her to have a good through the number of bedrooms out of her. Right now, please. Please, flat everything involved. You get okay about
Mr. Kelly. Let's see.
Twenty-three CR 2261 is called. Ricardo Kelly, that is you? Yes. Present with Mr. Adams, your attorney and the state's attorney does. The defendant waive a formal reading of this indictment and arraignment. And can we proceed in summary?
Yes.
In summary, this indictment, sir, which was handed up by the grand jury on December 13th, 2023, alleges that on or about August 31st, 2023 in Jefferson County, Texas, you committed for the state jail felony of theft of services involving a Mazda automobile under some kind of a rental agreement that because I guess violated. And you understand what you're charged with here. If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. Additional, you may be assessed a fine not to exceed $10,000. Do you understand? Agreement's been reached. You'll be pleading guilty and sentenced to 2 years in the state jail. That would be suspended. You would be placed on 5 years regular probation. And there's restitution here in the amount of $24,282.
Yes, Judge.
Where'd the car go? Was it wrecked or something or what?
Well, it hadn't been returned.
Where is it?
He doesn't know where it is.
You don't know where it is?
No.
I'm asking you.
As I explained before.
Let's play like I don't have 5,000 cases. Tell me, what did you explain before to me?
I explained that I rented the car for a friend, and the friend didn't do right with the car. Now the car is missing. I don't know where it is. I've been trying to find it. So it's no point in me trying to get him to come to court to try to help me with this. So I'm willing to take my rap, take my probation, and get it out the way.
Judge, this has been reset several times for us to be able to find the car. The car hasn't been found.
What are y'all going to do with the quotes friend who's sticking it to him?
I actually went to the police station yesterday to talk to someone. I did talk to a sergeant. He did state that if I was able to come up with the information about the car, he would look the car up just to see if the guy, just to prove that the guy was the last person that had the car, possession of the car. So
As of now, our office doesn't have any additional cases regarding this cause.
Are you gonna pay back $24,282?
just have to work and do what I have to do, sir.
Well, how much are you able to pay?
I don't have nothing right now, so.
You don't have a dime you can pay it?
No.
Mhm. Must be nice to be able to not have to pay $24,000 and give a new car back, huh? And then scamper away on probation.
I mean, the point of being on probation is to pay or get a job.
No, it's not. That's not the point, sir. No, that's one of the factors. Restitution. You don't even have a plan for restitution. You have nothing to give right now. I mean, this happens a lot up here where people come in, get probation, and then scamper away, and they never pay a dime to the people who are lost, and the people who, I guess it's Avis, are out the money, and they never get the money. Right. What do you do for a living?
Right now, I'm a shift leader at a restaurant.
Okay, and is that a salary or do you get an hourly wage? How much do you get an hour?
$11 an hour.
No, that's 22,000 over a year. So how much are you going to be able? Have you thought about a payment plan of how you're going to pay this back, like per month, like a loan?
However it's going to go, I just have to go from there. But I don't have a plan until it's orchestrated. So once it's orchestrated, then I go from there. I just have to work.
Okay. You know, when you made the deal with Avis, they made the deal with you. They didn't give you permission to let that car go to anybody else. You know that, don't you? That's like fraud, because you signed a contract saying you were going to take care of it and that it was not going to be let to someone else. Well, you violated that contract and then the car is gone.
Why don't you pay the, whatever was the rental fee per day, pay that as restitution? Can you afford that, whatever was the rental fee? That'd be an idea.
All I know is I can just do my best and work. I'm already in a situation behind somebody else. I understand I signed my name, but this was the point of trying to help someone, and it messed me up in the end. I'm sitting here admitting that I was wrong for signing my name and letting them use the car.
That's true. But he's got some responsibility too.
He don't want to come in.
That's true. I hope the district attorney's office is looking into that too, because that's he knows. He's taken something from this man through Avis, and that's kind of like stealing, isn't it?
Yes, Judge, we can follow up on
That's theft. And there's no reason why that person shouldn't be looked into and him be held accountable as well.
If it was me that did something to the car, I would admit and take it, but I didn't do nothing to it but sign off on it.
No, but you loaned it to someone without the authority to do that. You were giving someone else's property, which you shouldn't have done. That's why you're in a mess. And he's in a mess too, because you were responsible and then he betrayed your trust. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily because you are guilty? That's a question. Yes or no? Are you pleading guilty because you are guilty?
I'm guilty for signing.
Yeah, that's yes or no.
It's a yes or no.
Yes.
Yeah, guilty, but it doesn't mean it's either guilty or not guilty. Here, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tendered?
No.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, it states. So help you God. States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
All right, I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement will be suspended. You were placed on regular probation for 5 years. You must pay restitution to Avis and the complainant in this case in the amount of $24,282. There will be other terms and conditions of probation, which are normal and customary for the circumstances of this case. Also, as a condition of probation, you will fully work with the district attorney's office and law enforcement officials to take all efforts to get that vehicle back. And you will fully cooperate with the authorities in that regard. Do you understand? I like that guy. Brought to justice and get in here as soon as possible. Everybody with the state if possible, please.
Yes.
See what you can do about that. All right, anything else? That is all. Please see the probation officer.
Yeah. This issue.
Okay, I have a dismissal here in Jalen Brown, 25 CR 1215. That case is dismissed in lieu.
Alrighty, friends. Hour 3 of TCF Live. Good to have you all here. Let's change it up. Let's go to Louisiana, check in on the board where a shadowy figure appears to be sitting for judgment this morning. Oh, there's a little bit of light on him now.
I think your microphone's on mute. Can you unmute the mic or ask somebody to do it? Can you get somebody is anybody in the room with you?
Excuse me.
Oh wait, I can hear you now. Will you tell me your name and DOC number?
Rajarius Calvin, 728-223. You mind if I stand up and shut this door real quick?
Yeah, sure.
What is his name?
You're in Washita?
Yes. Washita Parish, OCT.
Yes. Okay, I got you. Rajarius Calvin.
Yes, ma'am.
All right, let me get your files. So you're here this morning for a revocation decision. And we're gonna get your file. You don't have any paperwork there with you, do you?
They just gave me just this Louisiana Board of Parole revocation questionnaire, just this one.
Is that your signature down at the bottom of that page?
Yes, ma'am.
Okay, good. That, based on the information contained in that form, you're not eligible for us to appoint you a lawyer. So are you ready to proceed today without a lawyer?
Yes, ma'am.
Okay. Well, you'll see on the screen, Ms. Jerry Ledoux, your case has been assigned to her, so I'm going to just let her take the lead.
Okay. She's muted. Okay.
Okay. Mr. Calvin, what I'm going to be doing is reading out some allegations that you have violated your conditions of parole. After I read each one, I need for you to enter a plea of guilty, not guilty, or guilty with a statement. You're accused of violating condition number 4, in that on 2/13/26, you were arrested and booked in the Washita Parish Correctional Center on a warrant for domestic abuse battery, second offense. according to the police report from Monroe PD, on 12/20, at about 4:32, you battered your girlfriend at her residence by pushing her into a glass mirror, causing it to shatter, punching her in the face 2 or 3 times. The officer noted the injuries on the victim's face, and they were consistent with her statement. A warrant without bond was signed, and you were placed in a parole detainer. However, on March 25th, 26th, the state declined prosecution of the case. How do you plead?
Not guilty, ma'am.
Okay. Are you pleading? Now let's ask something else. Did you and your girlfriend get into an altercation in December?
No, I'm not aware of no altercation, ma'am. Of no December, no, ma'am.
Okay, so were you at your girlfriend's house? Sir, I'd like for you to remain seated straight up so I can see your face.
I can barely.
Okay, so you're having trouble hearing.
Yes, ma'am.
Okay, let me speak more loudly, okay? Did you and your girlfriend have a situation where a mirror was broken and y'all were together?
I mean, it was a situation where I think I cheated. When I cheated on her, she became upset and the mirror was shattered. But as of a physical altercation, ma'am, no, ma'am. It was something that happened that I felt like I should have been in person to talk to you guys that really don't have nothing to do with this case that happened. But as a me, I get into a verbal altercation, no, ma'am.
Okay, so you've already had one domestic abuse battery charge, is that correct?
Allegations, yes, ma'am, that I was never convicted of, that I supposedly, that was a shock to me when this case came up. They said I supposed to have something against me that I wasn't aware about. It was supposed to be in 2014 or 16 or around about that area.
Okay. During your time incarcerated, did you ever take any classes on anger management or anything?
I took CPR and anger management was my next one, but I took my CPR, got my forklift, chainsaw, and I was doing entrepreneur classes. I guess we got to get this type of code just to get it. It's on Cypherverse that we got this code that we got to get our certificates, get them downloaded and all that. But I have been taking classes on. We have this tablet thing we go on.
Okay. Whether someone is charged with a crime, if we have evidence that it happened, then your can possibly be revoked. You realize that?
That's not understand.
Okay. Did she write a letter saying it didn't happen?
I have no altercations. I have no letters, no nothing. No, nothing.
Okay. She's not here today. What is your relationship with her?
Over with.
She is here. We got a late check-in. She is on Zoom.
Oh, okay, thank you, Ms. Renaud. I was unaware of
And
that.
so is the parole officer.
Well, he wasn't able to log in.
Oh, I'm sorry. He said he's going to observe. He wasn't able to log in. But Ms. Keys is on Zoom and says she wishes to speak.
I would like to hear from her at this time.
Ms. Keys? Can you unmute your microphone, Ms. Keys?
It's unmuted.
Okay. Go ahead and you tell us what happened.
It was a verbal altercation. That night, the police got called by the next door neighbor. Officer Torres pulled up. I wouldn't say much. He walked through the house and wrote his report from what he saw.
What really happened? What happened between you guys?
It was a verbal. We was going back and forth. It was an argument.
How did the mirror get?
The mirror got broke because it got thrown some at it.
Did you have a protective order against him?
The state put a protective order against
Okay.
him when he got arrested.
Okay. Mr. Colvin.
Yes, ma'am.
Oh, never mind. I was just curious. So you're saying you never touched her?
No, ma'am. We never got into like an altercation where I had to put my hands on her.
Okay.
Question is legit. Mr. Colvin, why do you believe the officer who responded to the call documented visible injuries, if no physical altercation with Ms. Keys took place?
I not to be speaking overboard, but it's just be on the safe side, ma'am. I have no idea. It's just a pro mom state and a pro protective woman state, and I know it's a buku situations out there with this right here where they have to take these type of situations serious, but I have no idea, ma'am. I wasn't there.
You weren't there at all?
I know I had left, like, after me and her got into altercation, verbal altercation, I left the home.
What do you believe caused her original statement to law enforcement, which says you pushed her into the mirror, causing it to shatter, punched her several times in the face, pushed her into the bathroom door, pulled her hair, banged her head on the floor?
I have no idea, ma'am. Like I said, I upset her, and I guess that was a way of getting. I know I upset her very much that day. It wasn't a physical altercation, ma'am.
Ms. Keys. Ms. Keys.
No, it did not happen. And that's why when he got arrested, I went to the DA office and spoke with the DA because what she just read, I did not tell Officer Torres. I didn't speak with him at all. And I had requested for them to get his camera footage.
Did he hit you?
No, he did not. The only thing that was shattered was the mirror, and I had cuts on my feet from the glass being on the floor. That's all.
Who called the police?
When the officer pulled up, he said that he had a call for a disturbance. So I'm guessing one of my neighbors called the police.
Are you afraid of him?
I am not.
At the very least, I believe that Mr. Colvin needs to have some domestic abuse battery treatment of some sort. We have a police report that indicates that you had visual injuries, and we cannot just dismiss that.
Yes, ma'am. The only visual injury that I had, like I stated before, was cuts on my foot from the glass being on the floor. Other than that, it was no visible injury.
Did you have any treatment? Did you go to the doctor or the hospital?
I did not, ma'am.
Ms. Chairwoman, I turn it back over to you.
What is the nature of your relationship now, Mr. Colvin?
Unfortunately, this has been a railroad to where me and Ms. Keys has been separated.
Okay. And is that still the case?
Unfortunately, yes, and me and her get separated.
You may have to, or you are?
No, we are.
Okay. All right, I have no other questions or comments. Ms. Ledoux, ready to vote when you are.
I'm not sure if we have the ability to,
For executive session?
yes, let's go ahead and go into an executive session.
I'll second.
We have a motion and second for executive session to discuss confidential matters without objection. We're going to be in executive session, Mr. Colvin, for a few moments. Just stand by. We'll be right back.
Yes, ma'am.
All right, we'll come back to see how this turns out. But in the meantime, let's go back to Texas and Judge Boyd.
Good morning. How are you? I'm doing great. How are you doing? Okay. All right. The court is calling 2026 CR 000208 State versus Bryce Rule. Can I have parties announced?
Eddie Garcia for Mr. Rule.
And are you Mr. Rule? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rule, did you review the true bill of indictment?
Yes, ma'am.
All right. Deputy Laura, are you able to move them on that end? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to proceed on the lesser included offense of attempted possession of controlled substance, PE one less than 1 3.
Okay. All right, any objections?
None, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, the state is proceeding. Just one moment. Let's go off the record just briefly. Well, not necessarily, but
All right, we're a couple minutes on the way back. Let's see if we can push past this pause here, or this muting.
a possession of
There
a
we go.
controlled substance, well, attempted possession of a controlled substance, penalty group 1 less than 1 gram. That makes that a Class A misdemeanor. So the range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into this plea bargain agreement?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rule, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right, according to the plea bargain agreement, the state is proceeding on the lesser included offense of attempted possession of a controlled substance, penalty group 1 less than 1 gram. They're asking that your punishment be assessed at 28 days in the Bexar County Jail. There be a $500 fine. And are you all anticipating that this judgment is satisfied? And they're asking that your restitution of $120 be paid to the Bexar County Crime Lab. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
TCF receipts exhibit 1 and all.
No objection, Your Honor.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Can you tell me, sir, who is Gilbert Diaz to you?
My friend.
Okay. All right. The court will follow your agreement. The court will sentence you to 28 days in the Bexar County Jail. There's a $500 fine, time and money to run concurrent. $120 restitution to Bexar County Crime Lab for drug testing. There's to be no contact with Gilbert Diaz, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, so here's the thing. You're gonna have to start making better life choices. Otherwise, you're gonna find yourself in and out of jail, in and out of prison. If you have a drug or alcohol problem, which it appears you do, because of the people you're hanging around with, normally people who don't do drugs on a regular basis would not be around people who are using drugs on a regular basis. So when you're released from jail, you need to find a place to have a sober support meeting or either go to a facility for inpatient treatment. Otherwise, you're going to come back. And only 2 things going to end up happening if you continue on this path. Either you're going to end up in prison, at somebody's jail, or either somebody's going to be identifying your body. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you so much.
You're welcome.
God bless you.
Oh, thank you. God bless you too.
Okay, you can put this in your pocket. Okay, sir.
Alrighty, friends, let's head back to Louisiana and get the outcome of that hearing.
All right, Mr. Colvin, we are back in regular session. It's 9:05 and we are here to make a decision in your case. So I'll go ahead and vote first. Mr. Colvin, I'm concerned about the situation. I think something happened. I don't know who's not being forthcoming in our discussion today. But I was pleased to hear that you're separated. I think you need some help to learn how to deal with situations like that. So my vote would be in lieu of revocation, that you be sent to a facility that can give you a substance abuse evaluation as well as domestic violence prevention training. And once you complete the training, you'll be released back to supervision. You understand? You're on mute still. You can't hit the button to unmute? You don't see a microphone on your screen?
You're speaking to Colin, right?
Yes.
Okay.
She's there.
Miss-
Can you hear us now?
Mr. Colvin's on mute. Is the officer?
All right,
There
y'all hear me now?
Yes, we can hear you.
All right, you said you was gonna recommend me to a treatment what is this going on?
A program.
I can't even see you guys anymore. All right. Like I kind of been classes since I've been in here on the tablet for that already.
Right now, you need specific training geared to domestic abuse classes. And then I would add a special condition once you are released that you're to have no contact with Fulnavia Keys. You said you're separated, so that's my vote. I'm gonna let my colleagues vote. Mrs. Ledoux?
Yes, I believe that there's a need for domestic violence prevention training as well as a substance abuse evaluation. I concur with my colleague, no contact with the victim.
Mr. Tillis?
I concur.
All right, Mr. Klein, we're gonna get you some classes, some specific training, and then you'll be released back to supervision.
Like,
Do
do y'all know how long it's gonna take?
Alrighty, friends, coming up on the last half hour of TCF Live here on this Tuesday. Let's go back to Texas and Judge West.
Good morning, sir. You're Samuel Harmon.
Yes, ma'am.
And this is cause number 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385 charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed them.
Is the offer, let's see.
Judge, he had previously rejected 15. I re-urged that today. This is their first appearance with this newer charge
Right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are gonna give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket.
Yes.
Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be, they try that and then you could turn around and try the next one as well.
Yes, Judge, we'd be seeking to stag.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent.
Well, it would be up to me. So it depends on if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay, the plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay, and you want to go to trial?
Yes, ma'am.
All right, we'll get it set for trial. Then you can go back with the bailiff. Mr. Lewis, you have Jason Weinberg. It's a sentencing.
Yes, fine.
Yes, was there that yes, yesterday, and I think it's the same when he didn't.
Oh, did they not do an? You're right. We didn't get an update.
It's the same one.
So I put him in custody. So he didn't show for the PSI, and I put him in custody so they could go do a PSI, but I didn't get any kind of update. And I didn't notice that. So this is Jason Weinberg, and we had the pre-sentence report done, but he didn't show up. So I put him in custody for them to do that part of it, and I don't show that we have that. Can you check on that for me? And I'll hold the case and see if did probation go out and talk to you? All right, I'm gonna reset it 1 week. I need somebody to get out there this week, talk to him so that we can get this taken care of next Tuesday. Please, ma'am. All right, somebody will be out there this week. Sorry about that. Stacy Tyler, Mr. Lewis.
Yes, ma'am.
Good morning, ma'am. Are you Stacy Tyler? Yes, ma'am. And this is cause number 26, DCCR 0800. Ms. Tyler is charged with aggravated assault with a deadly weapon. Mr. Lewis, what is the announcement?
Judge, I've been talking with Ms. Tyler, and initially I was thinking it was just some mitigating information I was going to be getting to the state, but there is some that is material to the facts of the offense. And so I am asking for a little more time to do that, especially considering what the offer is from the state and her exposure.
Okay. And do you already have that, or you're waiting to get that from?
I am waiting on a little bit of it.
Okay.
So but it shouldn't take me too long.
Okay, so I'm just going to do a normal reset, Ms. Tyler, so that Mr. Lewis can get all of that information from you or whoever's getting that to him, get that information to Mr. Nichols, and then we'll get an announcement at the next court date, okay? You can go back with the bailiff. Janae Langerlow, Mr. Lewis?
And we're not gonna need her out.
We don't. Hold on, okay.
That's a situation where initially she was set for competency, but had refused to see Dr. Capone. I've gotten that worked out to where they can come over and see her at the jail. See her here.
Oh, I thought that was.
And
Can you get that?
we were trying to see if we can do it next week. I've been talking with Dr. Capone's office.
Okay.
We're trying to see if a date can be known where she can be brought over next week.
Sure.
I need to give Kelly on that.
All right, we'll just reset, a normal reset, and we'll get her brought over next week. We're not in trial next week, so it shouldn't be a problem.
Okay.
Mr. Parker, you've got Jacoby Murphy.
Jacoby Murphy.
Yeah. We get the point.
Yeah, you're right. That's why I didn't give you a breakfast out there. And 23rd. Yeah.
Good morning. Are you Jacoby Murphy?
No.
And Mr. Parker, will your client read the formal reading of the motion?
You will, Your Honor.
Mr. Murphy, in cause number 23, DCCR 0900, I have a motion to revoke your community supervision. Shows that you were placed on probation April 1st of 2024 for the offense of theft of property, a state jail felony. And that was, could you make sure, hold on, could you check that and make sure it's fine? Sorry. That was a 2-year term that was probated for 5 years. Is that correct?
Yes, ma'am.
And it alleges in this motion that you violated your probation. Count 1 alleges
Judge, I
that,
believe we would abandon that one. That one was not filed.
okay, just that one.
Just that one.
So we'll, count 2 alleges that you committed the offense of driving while license invalid, March 14th of 2026 in Bexar County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department, March 10th of 2026. Is that true or not true?
True.
Count 4 alleges that you failed to gain permission from Jefferson County, to leave the county, and that you were in Bexar County on March 14th of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to immediately report to the probation officer your arrest from March 14th of 2026. And is that true or not true?
True.
Judge, we can abandon the rest of them if you will.
All right. And so, Mr. Murphy, did you plead true to counts 2, 3, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Murphy is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that. If you have any questions about the law that prevents you from having a firearm or how long it lasts, you can talk to Mr. Parker.
Yes,
All
ma'am.
right, good luck to you, sir. You can go back with the bailiff. I tried to make it short and then I mixed it up and made it longer and different.
Alrighty, friends, about 20 or so minutes left, 25 minutes, something like that, here for TCF Live on this fine Tuesday. Let's go back to Louisiana. We'll give the board another try.
Woods, is that you?
Yes, ma'am.
So for the record, sir, would you tell us your name and DOC number?
Aaron Dale Woods, DOC number 587258.
Mr. Woods, you have counsel here with you this morning. Would you please introduce yourself for the record?
Yes, Attorney Gary Blaylock, for the record, Your Honor, out of Monroe.
Thank you. And you also have Mr. Woods, your mother, Miss Sharon Walker Woods, is here. And we're going to call on her shortly. She wants to say something on your behalf. First, do you have some paperwork there with you? Well, you've got a lawyer, so I don't need to go over that parole revocation questionnaire with you. We'll just record his name into the record. So your case has been assigned to Mrs. Ledoux. You'll see her on the screen. Your case has been assigned to her, so I'm going to turn it over to her.
Okay. Mr. Blaylock, I'm going to be asking your client to enter a plea to various parole violations. At any time you need to assist, you may do so. But Mr. Woods, you've been accused of violating conditions of your parole. Condition number 2, you failed to report to the Monroe District Office since your last personal contact on 3/13/25. Your whereabouts were unknown until you were arrested on 6/27/25. How do you plead?
Guilty.
Okay. Number 3, you failed to inform your parole officer of an updated place of residence since 3/14/25.
That's guilty.
You were arrested on 6/30 of 25 for simple burglary, unauthorized entry of an inhabited dwelling by Ouachita Parish Sheriff's Office. How do you plead?
Not guilty. Your Honor, yeah. Okay.
Is it my understanding that you were in court June 18?
Yes, ma'am.
Okay, and what were the results of that?
They gave me a trespassing charge, a misdemeanor trespassing. They dismissed the burglary and the unauthorized entry.
So, what was the sentence for the trespassing?
Credit time served.
And also number 10, you have an arrearage of $1,320. How do you plead on that?
Guilty.
So, it seems pretty cut and dry in my mind. Would you like to make a statement about what was going on and why we are here today?
Yes, ma'am. I'm not really trying to just make no excuses, but the girlfriend that I had at the time, me and her, we had lost our house, and she just found out she was pregnant at the time, so I was homeless. So, and I'm from another parish, really, and I really didn't have nobody like that I could try to get a place to go live at, and then just fell on hard times. Like, I know I should have called my parole officer, probably could have helped me with
Yeah, Mr. Woods, you're a 5th class offender. This is not your first time on supervision, I don't think, right?
No.
So you kind of know communication with your parole officer is key to success.
Yes, ma'am.
Okay. So where was the unauthorized entry, simple burglary? Where did that occur and what was the circumstance?
It happened at the trailer park that we was living at, and I had purchased the phone from a woman for like $50, and it was really a broke phone. It really didn't work. Like it was a contract phone, but I ended up getting the phone from her, and her and my girlfriend had gotten into a little dispute, and my girlfriend was threatening her, and she tried to come buy the phone back from me, and I already had sold it to the Eco ATM at this time. And for her to be able to get the phone back, she had to do a police report. That's what the Eco ATM people told her. So she made the police report and said that I either came into her house or I came into her car and stole her phone, which was untrue.
Mr. Tillis, I think that's the two things that'll get you in trouble, phones and women, right?
Yes, I
am. I'd like to hear what your attorney, Mr. Blaylock, you have any comment on this the situation?
Yes. So I've represented Mr. Woods on his criminal charges. So I was contacted by Miss Woods, Miss Sharon Woods, who's present on video. That's his mother. And so she came and saw me while Mr. Woods was incarcerated, and she wanted a plan, or she wanted me to help Aaron, but she also she knows that there's been an issue with his life with drugs and sobriety and whatnot. So she knows that he needs a foundation when he gets out, and he needs sobriety and he needs purpose. So what we talked about was a structure for when he gets out, because I think that's very important. And me and Miss Woods, spoke, and I told her that honestly, she's going to have to go through sobriety and whatnot to help her son out. So we came up with a plan that I would help Mr. Woods represent him on these charges if she, addressed her sobriety. So, and this is an issue that I was going to bring up in this hearing. I wanted to present exhibits. However, I just got this letter last Thursday from Mr. Woods. I need to present these exhibits to show the board that what we're trying to do
is get him into positive direction, which is a sobriety intake treatment program. So as I stated earlier, Miss Woods, she started this. I got a certificate that she completed that. She's currently living in a sober living house and seeking work, and she's working on sobriety. And I have documentation of all that. And as well, I have documentation that we have everything ready for Mr. Woods to be accepted and start this treatment process if this board will allow that. Now, this case, there was an issue, obviously with the phone. I talked to the prosecutor. We talked to the victim of this case. Everything's resolved around that. So, is it the board with that preference that we be able to present these exhibits so y'all can review them, or do you want me to address them and submit them for review afterwards?
We have some tools also in our within the department that we can address some of those things with. I think it would be important to allow Miss Sharon Woods, to make a statement at this time.
There she goes.
Okay. This
Yes, go ahead and just make a statement to the panel.
Oh, yes, ma'am. I'm Sharon Woods. I'm Aaron Woods' mother. I've been his mother all his life. He struggled with drug and alcohol just as I have since his grandpa died. And that was like 21 years ago. He was 12. And he struggles with toxic relationships, not only, with drugs and alcohol, but with toxic relationships too. And he's done things because he was addicted. And the program, I went through rehab and I graduated the program, and I came straight from the rehab to sober living. And I changed my people, places, and things. And I believe that's what he needs too. And he needs help for his problem, for his drug problem. And as a mother, it hurts me to see him repeating the same patterns because he didn't get the help he needed when he was younger. But I'm a living testimony that this thing works. And he has admitted to me that he has a problem, whereas before he didn't want to admit he had a problem. And so I'm willing to, while he's in rehab, to pay his parole and probation fee. I'm on disability, but I also volunteer at the food bank 2 to 3 times a week. And it's a very good program. The guy that runs this house will be putting him, he's a discharge planner at Positive Directions. And he said he would go straight from the 28-day rehab, the rehab at Positive Directions, straight to sober living. And he has 2 weeks to find a job. And here in Baton Rouge, it's very easy to get a job. And I'm willing to help him financially and emotionally, and while he's in the rehab.
Thank you very much. And I'm glad to see that you're working on your own situation, and that's very positive. Mr. Woods, during your time of incarceration, have you ever had any kind of substance abuse treatment?
Yes, ma'am. I completed on my first jail sentence. I did a 150-day drug, substance abuse program in Concordia Parish. And
Do you
then,
remember the name of that? It was just within,
I can't remember, it was back in
It's
2000.
it's an RSAT program in Concordia Parish.
Yes, ma'am, 150 days.
okay. And you're still struggling with substance abuse?
Yes, ma'am.
Okay.
It's like I get out and I'll be doing good for a while, and then I might lose my job or just fall on a bad time and run into one of my old friends or something like that and just fall off, thinking, oh, I can just do it one time and maybe just do it for this one time during this weekend, and then I'll stop, and then it just goes downhill.
Did you hear what your mother said? What she changed?
People, places, and things, yes, ma'am.
I know you learned that in Concordia.
Yes, ma'am.
It's a truth. It's a truth.
It really is.
Okay. Well, do you need another refresher on your substance abuse treatment?
Ma'am, it probably wouldn't hurt.
Do you want to be clean?
Yes, ma'am. I'm tired of living like this. I'm tired of being in jail. I got a 3-year-old daughter, and I just found out I might have a 1-year-old daughter, and I'm not trying to be like my daddy, not be there and them not know me. I want to actually get out and be able to do stuff for them and them to be proud of me. I'm not nothing to be proud of right now.
Well, the only way that I would be comfortable with you going back into society is after more than 28 days. So are there any other questions from my colleagues?
Now, let me just ask one, and then I'll be anxious to hear your plan. Mr. Woods, you mentioned part of your cycle is that you get out, you do good, and then you lose your job. Have you reflected on why you lose your job?
So I have sometimes like, and it's been me. It's been me
Yeah.
like.
No, I think, would you associate your drug abuse with?
Yes, ma'am, me losing it.
Okay, just, you got to look at those things. That's not easy to look at, but you got to do that evaluation yourself. Okay, Ms. Ledoux, I'm ready to hear anything you may have to say and vote.
Well, I think that, you didn't report for 3 months. You were in bad shape. And the problem is drug use, illegal drug use is always going to put you where you are. And so my vote would be to, in lieu of revocation, send you to a DOC substance abuse facility long-term. And then part of that would be to discharge you to a sober living facility after that. Okay.
What's the long-term 90-day facility or?
They are evaluated by the Department of Corrections, and there are several different options. And so it is generally 90 to 160 days.
Okay.
Thank you, Mr. Knotson.
And I also think you would benefit from that. So my vote today also is, in lieu of revocation, send you to a DOC facility for a long-term substance abuse program, and then discharge from there to a sober living house. And I think your attorney has set that motion in place. So hopefully that will be available for you. We'll work with you to ensure that happens. But you got to do the work.
So I'll be going to like another jail facility rehab?
Yes. Hopefully it'll be the Steve Hoyle program. You ever heard of that one?
In Bossier?
Yeah, North Louisiana. Yeah. Well, you're in North Louisiana now, aren't you?
Yes, ma'am.
Okay. All right. Well, look, good luck to you. You got a lot of work to do. Don't disappoint us. I hope I don't see you again on that screen.
All right, thank you.
Thank y'all.
I love you,
Thank
Mom.
you. I love you too.
Maybe I missed it, but did the guy vote? Because I don't remember hearing his vote, but whatever. We got a couple minutes left. Let's go back to Judge West. We'll do one or two more hearings there to finish off the day.
Say Amador.
Yep.
And Mr. Parker, will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Amador, in cause number 15-21599, I have a motion to revoke your community supervision. Shows that you were placed on probation March 27th of 2015 for the state jail felony offense of DWI with a child passenger. And that was a 2-year state jail term that was probated for 5 years. Is that correct?
Sure.
Is that right?
Yeah.
Okay. Do you understand?
Yeah.
Okay.
He does.
Count 1 alleges that you violated your probation. It alleges that you committed the offense of public intoxication April 9th of 2019 in Hidalgo County, Texas. And is that true or not true?
Yeah, man.
Is it true?
True.
Okay. And then count 2 alleges that you are behind in your court assessed fees. Is that true or not true?
True.
And then count 3 alleges that you did not immediately notify your probation officer of your re-entry into the United States. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Did anybody force you to plead true?
No.
Did you?
Did you plead true because they actually true? Well, yes.
Okay, so all of those are actually true.
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these documents, did you go over them with Mr. Parker?
No.
Do you understand the documents that you signed?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Amador is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish, and so you can read it so that you understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, you can talk with Mr. Parker. All right, good luck to you, sir.
Okay.
Alrighty, friends, that will do it for this morning. Thank you all for joining me. I hope you enjoyed the show. We'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. And, of course, we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. Join me a half an hour earlier than that if you're a channel member. The wisdom I leave you with for today: don't hope for a life without problems. There's no such thing. Instead, hope for a life full of good problems. So chew on that as you go about your day, and I will see you all soon. Take care. God bless.